really looking forward to this show.
Good.
I'm Jay Fidel, and next to me is Stephanie Thompson. She's an attorney and litigator with Starn, O'Toole, Marcus, and Fisher, Starn Law. And we're talking about technology today here on Life in the Law. Technology changes in the practice of law. Welcome, big welcome to the show.
Thank you, Jay. It's great to be here.
And a shout out to Caroline Lee, Vice
Yes.
President, Chief Operating Officer, former Associate Dean of the William S. Richardson School of Law, who knows Stephanie from way back and who procured her for this show.
Yes, thank you, Dean Lee.
Okay, anyway, wow. And so, of course, you can be a litigator. Well, a lot of lawyers, I mean, maybe a fair percentage of lawyers, probably a third or more, maybe even half, are litigators, like it or not. But you're more than a litigator. You're a technological litigator, which adds a whole new dimension. How did you get interested in that?
Well, Jay, it was kind of thrust upon me from one of my very earliest cases where we were involved in an extensive, expensive lawsuit. It was one that we like to call bet the company litigation, that if the company loses, it could mean the life of the company.
Oh, wow.
And we received a number of requests from plaintiff. We were representing the defendant, and we had to go to the defendant, a rather large company, corporation, and say, okay, where is all this information? We need to gather it, we need to collect it. And the company at that time was not situated to produce or go easily direct us to this type of information. So it was a lesson of learning by doing, and I learned very quickly some of the mistakes one makes in how companies store information or what can happen when you don't ask the right questions of companies. And then I also learned that she or he who has command of the documents really has the upper hand in any litigation.
Isn't it true?
It is.
This wasn't always the case. I mean, documents, you know, going back to my old days, you know, in the old days, a complaint was 2 pages long.
Yes.
Okay. A lease was maybe 10 or 20, maybe less. Documents in a trial, there weren't that many of them. And it was a few, maybe. But the world has become more complex.
You're absolutely right. Much more complex.
And litigation has become more complex, for sure.
Yes. Now in today's market, with businesses, it's somewhere well above 90% of all the records stored by businesses are stored electronically. So you can imagine if a business is doing well, if they're doing good things, they most likely will, or they have employees, they will face some type of litigation in the near future. And so
what a thought. There you
it's
go.
unfortunate.
That's the way it works.
It's unfortunate, but a sad fact. It's a true fact. And so if businesses could put themselves at a position to where they know where things are stored and it's stored correctly, when they are sued, they can produce those records easily, quickly, thereby saving a lot of money and hassle.
Yeah, and you can't invent a storage system, you know, after you're in a litigation situation. That's not the right time to do it.
That's not the right time to do it, no. So this is where I became proactive. I'm a litigator, so I'm engaged in the business of trial and going to trial, and a huge portion of my time is spent in this process called discovery. And discovery, as you know, is once a complaint is filed and defendant answers, then the parties say, okay, show me what you have, and I'll show you what I have. And the rules are set up for us to be very, very wide open. In fact, the rules were changed recently to make this whole concept of electronically stored information more easily obtained. So because most cases do not go to trial, it's less than 1%, the bulk of the expense of any civil case is in discovery.
The trial is within discovery, essentially.
Usually it is.
You see what you got, and see what he's got.
Exactly.
And then you can figure out who's going to win a trial. So it's a trial, a hypothetical trial through that discovery. And as you said, the person who controls the information, the documents, has a huge advantage. And I bet you see all the time people who don't have that advantage, who've mucked it up somehow. Companies, or for that matter, lawyers, who don't know how to either file or retrieve documents they need for a trial.
I do, and more because of the trend towards technology and electronically stored information, courts are placing the responsibility and the onus on the attorney to ensure that when they go collect documents that in turn they have to review and produce to the other side, that they're doing it competently, thoroughly, that they've informed their client to not delete everything, that they make sure that they have all their bases covered. And quite frequently, if the attorney doesn't do a good job, the attorney or the law firm is sanctioned for it.
Yeah.
So that is where my motivation has come. As a litigator, I'd like to, and I do, educate my clients as to, okay, where are we at? This is how you store it. In the event that you're sued, we know where things are stored, how they're stored, what custodians, and that's the keeper of the information, where we need to go to get it, and it's very easily obtained.
Yeah.
So of late, I've developed a seminar to take basically out to certain businesses, because quite possibly I will be on the other side, you know, defending or suing. And if I know that the other side has kept all their documents and has it easily stored, that this whole process of discovery will be much more easy.
How do you give them credit for that when you settle the case?
Yes.
If you feel that they have control of their documents, you know, they're more credible to you.
Absolutely, yeah. Absolutely.
And you know, and early on, when electronic record keeping and discovery, you know, just started, which is not that long ago. I mean, I'd say, what, 20, 30 years ago, maybe. Maybe. You know, people didn't know how to do it, and they didn't know how to find out the other guy wasn't doing it.
Right.
Okay, and there was, what do we call it, a de facto kind of forgiveness. Oh, this is too complicated. You know, we're not going to really push them on this. People don't do this sort of thing. And as a result, a lot of stuff fell off the table. You know, it was never actually found and disclosed. But that has changed. And now there's really no forgiveness here.
No.
You'd better have all the documents that relate to this thing. So, you know, the old problem was making sure you did have all the documents. And so you wind up doing discovery into the way the guy is, the other guy, the adverse, the company on the other side, is keeping the documents.
Exactly.
And if he's not keeping them, you make a monkey out of him. Sorry. Because he doesn't look so good. He looks like he's hiding something.
Exactly.
And he loses both in the discovery and ultimately in the trial and in any motion practice with the judge. The judge is going to see this. You're going to make it known to him.
Absolutely. Yeah, absolutely.
And you know, you win by the other guy not having them when he should have them.
Right. And recently, especially at the federal level, the courts know this. They know the huge amount of information that is being exchanged and asked and generated by businesses. So they've changed the rules to accommodate this type of electronically stored information and this exchange of information at the federal level. Going out of the gate into your Rule 16 conference, you've got to know. You've got to know where things are stored, who has them, the systems being used by your business, and you need to know this and be able to share it with the other side within 3, 4, 6 months of filing your complaint. The rules have been changed, and some of the phraseology that we as attorneys are commonly accepted or used to, reasonably calculated to lead to the discovery of admissible evidence, that's out the window now. And now,
it's everything.
No, actually, it's actually that which is relevant, but there also has to be a showing of proportionality. If I have
what is proportionality?
Well, if I have $1 million, I have a case that's worth maybe at the most $1 million, and somebody is asking for all emails that my company generated for the last 5 years, that's quite a bit of money. That's quite a bit of email. And so the court looks at what is relevant and how much is it going to cost this company to research, collect, produce.
That's reasonable, isn't it? But it's a qualitative thing, and the judge has to make a qualitative decision.
Yes.
And decide that proportionality.
That proportionality. And so because these rule changes went into effect in December 2015, now we have some of the cases at the federal level trickling in to say, okay, yeah, you're asking for too much. No, this is spot on. You should have produced this.
Yeah.
And
I think those precedents, those rules will that filter into the state system? Has it already?
Not at the state system that I've been able to detect. And usually what happens at the state level is the rule changes they come, but they come after the federal level. A lot of our discovery case law is based upon how similar laws at the federal level are interpreted. So it's coming. It's coming. And
but what about the age-old problem of the guy who secretes the documents? You know, fellow gets sued and, oh my goodness, we destroyed that a week ago. You know, it's all gone. We obliterated, deleted. There's nothing left of it. What happens with that now in the courts?
Well, because everything is electronic, nothing is destroyed. You may think that you are destroying texts, pictures, emails. One case in particular I'm thinking about that I was able to participate in, it was a dispute between two companies, and a third party we understood had some relevant emails and could have had dealings that were in violation of some agreements. So we went asking this third party for documents and emails. We had received emails up until a certain point, and then they stopped. And we knew they should not have stopped. And so we went asking and discovered that there were none, they didn't exist. And then we said, okay, that's not right. We got a motion to compel. We hired a forensic expert who went in and was able to retrieve those emails that one of the employees had deleted. And so we agreed to settle certain claims based upon, or stipulate to certain things based upon that discovery. Many people think that they can delete text messages, and there's really no way that you can delete text messages. You know, you might as well just, some people do, run over the phone with your car. You know, the only way to get rid of text messages is pretty much that. But everything is there, and it's causing some problems for businesses who have employees use their own cell phones because, you know, and when the employee leaves or there's company sensitive information or that phone is lost.
Hillary Clinton.
Yeah, there's problems, and some employees are not aware that could be a problem.
Well, take San Bernardino and the FBI, one of my favorite little stories. I mean, so Apple,
yes.
It depends on how you feel about Apple on this, but Apple made it hard to get the data on that cell phone. Mm-hmm. So now if you're in court and you know that cell phone can prove or disprove something, it's relevant and it's within proportionality, if you will.
Sure.
Okay, and you say to the guy, I want, and he says, I'm not going to give you the password, sorry. How do you deal with that? You get an order on that man.
If you can show that it's relevant and that it's not going to, and it is proportional, that it's easily obtained and can be obtained and it's very relevant to the claims. In my case, I will file a motion to compel, be very specific, and I would assume that the judge would grant that. There is a 2014 case out of Ohio, Federal District of Ohio, where it was a class action lawsuit, a wage discrimination claim. 600 of these hospital employees said that they were not compensated for their overtime. And in the process of going forward in this discovery, it was discovered that approximately 26,000 text messages on company-issued cell phones had been wiped. And the discovery master appointed in this case said, this is egregious, I can't believe this, and gave the 600 basically what we refer to as an adverse inference, that this is spoliation, that this, and the discovery master suggested a default judgment for that.
Whoa,
yeah,
that's pretty serious.
It's still ongoing, but I mean, if you think about a 600-person class action lawsuit, that is serious.
It's going to cost somebody some money.
Yeah, and the discovery master pointed to the fact that you knew, you had these phones, and you knew that there was litigation. You should have collected them, you should have downloaded them. It's very cost effective and efficient, and not let them be deleted.
One more question before we go to a break, and
Sure.
that is, so is it that I can't have a deletion system and automatically, you know, that if it's more than X years old, I have a system to retire that file, delete that file. Can I not have that anymore?
No, and that's a great question. One of the things that we do in our law firm and with our clients is make sure that they have a records retention policy, that it's in place and that it's followed. Because if you do get sued and they're asking for documents 8 years ago, and it's part of your policy to delete these as a matter of course, you can show that up until the point that the litigation, or you thought the litigation would ensue, you had been following that policy, you're off the hook.
Oh, that's good.
Yes, unless somebody else somewhere kept them without deleting them. So.
Well, and that's always possible.
That's always
be really
possible.
Careful. But if you follow a policy, you're not going to be scored on that.
No.
You know, you're not going to be defaulted.
Most likely not.
Yeah. Okay, well, that's a happy note, I suppose, in an unhappy world. We're going to come back and we're going to find out Stephanie's secrets, her software secrets. It's you know, it's finding the documents that you're really finding the little nuggets. We're going to ask her about that. That's Stephanie Thompson of Starr & O'Toole, Marcus & Fisher here on Life in the Law, Technology Changes in the Practice of Law. We'll be right back, you'll see.
Hi, I'm Donna Blanchard. I'm the host of Center Stage, which is on Wednesdays at 2 o'clock here on Think Tech. On Center Stage, I talk with artists about not only what they do and how they do it, but the meat of the conversation for me is why they do it, why we go through this. A lot of us are not making our livings doing this, and a lot of us would do this with our last dying breath if we had that choice. And that's what I love to talk to people about. I hope you enjoy watching it, and I hope you get inspired because there's an artist inside you too. Join us on Center Stage at 2 o'clock on Wednesdays. Bye.
Aloha. My name is John Waihe'e, and I actually had a small part to do with what's happening today. Served actually in public office. But if you don't already know that, here's a chance to learn more about what's happening in our state by joining me for Talk Story with John Waihe'e every other Monday. Thank you, and I look forward to your seeing us in the future.
Bingo, I told you we'd come back. This is Stephanie Thompson, Life in the Law. She's from Starr & O'Toole, Marcus & Fisher. She's a lawyer and a litigator there, talking about technology changes. And this is the part of the show we ask her about her secrets. Now, I asked her about her secrets during the break. She said, what secrets?
It's all open. Everybody has the same information.
But there are some things that we could offer you that are really valuable if you happen to be a litigator. What are they?
Sure. And this is probably nothing new, but you need to understand how to ask the right questions. School yourself very quickly, early on, with what the issues are and what kind of documents that your client has, and then I'll expect to see emails, drawings, Excel spreadsheets, even tax returns.
Give me an example. We're talking about a motion to compel or just a request for production.
For example, if my client, and we collect my client's documents and I review them, and I see that there's a number of email exchanges between my client and the office, the opposing party's office, but then also that very frequently the main principal is using maybe a Gmail account or his own personal account. And then when I get the other side's documents, no emails from this Gmail account. So I will know that, hey, they haven't produced everything. They haven't gone searching for everything, that he's used maybe another computer at home to access or to download certain things. And so I want to know what's on that computer. I want to know and go after that computer. If there's text messages, then I want to have assurance that they've gone and searched the phone and collected all the text messages off the phone.
So is the first step here to learn who's got what? Who's got the information? What kind of accounts are out there, whether they're in the company or outside the company, or do you try to wrap it all in one big request for production documents and ask all of that in one place?
Most often, well, first of all, going out of the gate, you do absolutely want to know who's got what where and be able to represent that to the other side. That's required under the federal rules, and it just is common sense under the state rules. And if you don't know, or the other party can't tell you, then you need to ask those questions. Get me this information. Are we going to have a problem with this? Where are things stored? And it just makes good sense that you set it up from the beginning. One thing about telling the other side, okay, this is what we've got, this is where it's stored, these are the custodians or the people involved whose hard drives we're searching, is that when that motion to compel comes, you can tell the court, look, see, I told them. Now they're asking for this. When we told them from the get-go, we weren't looking here, we're looking here.
Yeah.
So it kind of protects you as well to be, for lack of a better word, open kimono about it, to just say, this is where it's at, we're not hiding anything, let's go forward.
Yeah, and you don't want to ask, you don't want to go down this road when you could go down both roads, because it's hard to add a road later.
True.
You have to be sophisticated.
Exactly, and in litigation, you're always dealing with deadlines. And so you know you're pushing up to these discovery deadlines, or you're pushing up to the deadline in which you can file these motions to compel. So you need to know quickly if you're getting things, if you're getting information. So it's kind of a dance.
So you try to get as much as you can. It's, you know what it reminds me of? NSA in a funny way. You get it all. You get every email in the world, you get it all, and then you start picking through it. So it's okay to be expansive about this. And I guess the court, subject to that proportional thing, the court will allow you to do that, because the real discovery doesn't happen until you get it all there.
Right, exactly.
Right in front of you.
But it's one of those situations where be careful what you ask for. Because if you ask for everything, you're going to get, 45,000 pages of documents that you in turn have to load, and there is great software out there that helps litigators and doc reviewers review this stuff, but you have to load it, maintain it, and then do searches through it to whittle through. So you're going to be spending a lot of time and money.
Do you do that, or do you get somebody to do it for you?
Actually, we have a great system and wonderful people in my office who get the initial upload and then whittle through it. There's software now that you can teach it to think. You have all this huge expansive documents and you tell them the keywords, you tell them things like this, and then they go out and spit it out, and they'll spit back a result, and then you get, as an attorney, you get to refine it and say yes, yes, no, and spit it back out again, and then the search engine will do it all for you and then spit you out everything that you asked for.
Now suppose the document comes in PDF. It's not really searchable. It's an image document, or if it's a graphic. But on the graphic, there are words written on the graphic.
Sure.
How can you convert that document into text so you can search it?
Well, PDFs are OCR'd. You can read it and search it. You can OCR all PDFs, but in making a discovery request, now it's very common, and the rules allow for you to ask for the information, to ask that it's in its original or native format, and then if you don't have the software to read that, maybe it's a CAD system or something like that, then they get to supply that information for you, or that software, so that you can read it. You want to ask for each document has attached to it metadata. And metadata tells you when that document was created, how it was created.
Yes. That's a secret.
No, every document that you create has this background data about the document that you create. So you ask for certain metadata, so I know. You tell me that we entered this contract on August 2nd, and I get your draft of the contract, and it shows that this wasn't created until November, because you can't.
Bingo, I can see the cross-examination now.
Exactly. So that metadata is very, very important. And
especially in documents that are being drafted.
Yes.
Because the metadata sometimes will let you into the whole drafting history and comments.
Yes,
comments about
as well.
The changes. And we had a case, my firm had a case one time, it was really amazing, with a very sophisticated tech firm on the mainland. Okay, and they sent us a document. It was a negotiation, not litigation, but they sent us a document where they had not, flattened that document. So it was all there. And we could see all of their comments, all of their changes, everything they had done, all their work product was in the document.
Yes.
And then it's an interesting question about, wait a minute, that's our work product, you can't have that.
Right.
Well, we already have it.
Yeah, there's rules for that, as you know, Jay. There's rules about inadvertent disclosures, but courts are more and more, because you have all this software, you should know what you spit out, that they're less likely to give you that document back if you didn't do your due diligence as an attorney to review it and keep it back.
That means when you're giving up these documents, you have to look and see what you're giving. Some of it may be privileged or not disclosable, not discoverable for one reason or another, which means if you have 100,000 documents, somebody has to go through, right?
Yeah, exactly.
Every one.
Exactly.
Or the price is really high.
It's
if you
very
make a
high.
mistake.
Exactly. And there's a great case, I think it's out of California, where there was an inadvertent disclosure, meaning that the attorney gave something that they should not have given. He asked for it back. The other side said no. And he filed a motion for protective order, essentially asking the court, hey, I want it back. And the court went to the reviewing software that this attorney used and found that the attorney, when he was reviewing for privilege and work product, spent roughly 2-3 seconds on each document. And the rule is that the attorney must take reasonable efforts before he discloses or inadvertently discloses. And the court found that was not reasonable.
Not enough, so he had to suffer with the mistake.
He did. So there's software, you know, everything is recorded. When I open up a document, it logs in when I opened it, what work I did, when I closed it, and that's in all types of software.
What I get out of this is that everything is on the record.
Everything is on the record.
You know,
yeah.
Transparency goes everywhere about everything, and you can't escape everything you say and do. You have to assume, right?
Exactly.
You make a call, you write an email, anything you do is all discoverable in court. That's very scary. You can't, you know, Walden Pond is no longer available. The Great Woods in Alaska and the Northwest Territories, they're not available. We live in a complete crucible of transparency.
It is, and everything's recorded. I mean, when we talk about everything that has to be turned over, it's text, it's video recordings, it's social media, it's your tweets, I mean, that's all fair game now.
Yeah, but I want to talk about Google Boolean searches.
Okay.
You know, the measure of this at the end of the day is finding something in that 100,000 documents. It depends on your ability to form up a Boolean search that works. Mm-hmm. And then if it doesn't work, to form up another one that may work better. And so the lawyer does that, the paralegal does that. Who does that?
Actually, it's the software that does that.
Okay.
The software has great analytics
Yeah.
and something called like predictive coding,
Yeah.
where you can plug in a whole series of words and it will spit out the things relevant to that, and then you get something manageable. But really, eyes on the document and giving it the relevancy, that is a person that does
context,
that.
Yeah,
it's context.
So what's the name of the software you use?
Oh, there's a number of software, and I'm not going to plug a particular one, but we deal with
She says she doesn't want to plug it.
No, but there's software for the big bet the company cases, and then there's software just for, you know, the mom and pop lawsuit, you know. So you don't want something that's going to cost a huge amount of money to host, because thinking about it, when litigation starts, you have to hang on to all these documents now. You cannot delete. And a huge cost of litigation is housing and storing this amount of documents.
Yeah.
So that's a huge cost.
Yeah.
But
Well,
it's there, and it's a doable thing.
we have learned so much from you. Not all of your secrets, of course, but we have learned so much from you. Stephanie Thompson, an attorney and litigator with Starn, O'Toole, Marcus, and Fisher. Technology changes in the practice of law, and I feel that I have learned one thing. You got to keep current on all this.
Yes.
You can't take your hand off the stick for a minute. Thank you so much,
Thank
Stephanie.
you, Jay. It's been a pleasure. I appreciate it.